raise our hands up towards you, and we are thankful at all times to you. Today we invite your presence in another meeting around education. And Lord, you know that education is having its challenges. We pray for the teachers, we pray for the students, we pray for all those administrators, all who are part of this important system. We invite your presence to continue to guide us through these proceedings. These we ask in your merciful name. Amen.
Thank you so much, Member Gale. Apologies for absence. I think I have one. Well, two. Senator Dina Dixon and Honorable Robert Nestor Morgan and Senator Braham. Okay. All right. We'll move on to the confirmation of the minutes of the We'll move on to confirmation of the minutes of the meeting held on Thursday, April 25, 2024. Starting with page 1. Page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Finally, page 11. Are there any matters arising from the minutes? Or no, let me take confirmation. Moved by Member Gale, seconded by Member Miller. Any matters arising from the minutes? Go ahead. Go ahead, Council.
Good afternoon, Chair, members and colleagues online. Minister, we're asking, technical team, we're asking for some time to treat with the matters that would have arisen from the last minutes, or from this minutes rather, from the last meeting.
Just for the records, point out what those are so that we can recall in the very least.
So there is an issue in relation to the board as against the council. Yes, that's a matter needs to be sorted. And there was the matter of the transitional provision for those persons who are in the sector and would not have an authorization to teach. So there is not a transitional provision allowing them to obtain an authorization to teach within a certain time frame. Similarly to the teachers who are currently in the system who will be deemed registered when the act is passed, when the bill is passed. So the discussion at the last meeting, based on my recollection, is for those persons who would not be applying for a license to teach to get the time to apply for an authorization to teach, similarly to those persons who will get the time to apply for their license.
Was there one in relation to those persons who are part of the early childhood?
Those are the persons.
Those are the persons, okay. All right.
Sorry, those are two matters, or there are others, Council?
As far as I can recall, Chair, yes, those are the two.
All right, time granted until the next meeting. Is that sufficient?
Should be. Thank you.
All right, for today, we will continue the reading of the report, noting, of course, any issues as they come up. If we can deal with them in the moment, we will. If not, we will put them on a list to be dealt with. But it is felt that we should go through the report and just absorb the totality of it and come back to matters such as the board versus council and any other matter that comes up that we're not able to resolve today in this meeting. So we ended at clause 19. Yes. No, 19, because the committee did not object to the draft recommendation. So Member Gale, you want to pick up? You read very well at the last meeting.
As the last time, but I will continue. On clause 20, registers. Your committee noted the query whether a teacher would be granted a license in one subject area. Your committee was informed that licenses are not intended to be subject-specific. Clause 21, role of instructors. Your committee does not recommend any change to this clause. Clause 22, inspection of registers and role of instructors. Your committee acknowledged the concern whether the clause, by allowing information such as the address of registered teachers to be assessed by registered and licensed teachers and instructors, conflicted with the provisions of the Data Protection Act, and that this could also create a security risk for teachers recorded in the register. Your committee recommends that the bill be amended to indicate the information that the public or prospective employer will only be able to access the name of the persons in the register and whether that person is registered, licensed, or authorized to teach. Clause 23, correction of registers and role of instructors. Your committee does not recommend any change to this clause. Now we move to part 4, restriction of teaching. Registration and licensing of nurseries and daycare centers. Your committee acknowledged the recommendation for the bill to address registration and licensing of caregivers in nurseries and daycare centers. The rationale for the proposal is that these persons would not have the qualifications to teach. Your committee does not accept the recommendation and acknowledge that the Early Childhood Act regulates this area. Clause 24, prohibition against practicing as a teacher without being registered and licensed or authorized. Your committee considered several concerns raised by stakeholders regarding the severity of the $500,000 fine for practicing as a teacher without being a licensed teacher or instructor, noting that some stakeholders viewed it as excessive, while others indicated that it was not sufficient to deter wrongdoing. After extensive deliberations, your committee recommends a number of changes to the provision. A person who the council is satisfied is practicing without the requisite license or authorization should be directed to apply for the requisite license or authorization. If the person does not comply with that direction within the time period permitted, the council must direct them to cease practicing as a teacher. Where the person continues to teach without the requisite license or authorization, that person commits an offense. The penalty for that offense will be $500,000. Clause 25, offense of pretending to be a registered teacher, licensed teacher, or instructor. So there's no representation of clause 25 included in the report. So can we, there is?
The comment on the 26 covers both offenses.
Oh, so clause 25 and 26. Go back to.
Oh, yes. It's 25 and 26.
25 and 26.
Right. Right. The first thing I was going to do was to note an apology on behalf of my boss, the Solicitor General, who can't make today's meeting. The second thing I was going to note was that I wanted to intervene at the point of recommending the 500,000. And the intervention was to say that the idea from the recommendation is that the offense for fraudulent misrepresentation should attract a potentially higher
Agreed.
sanction than the offense for pretending. So that if you would decide that the offense for the fraudulent misrepresentation should be $1 million, then the offense for pretending should be less than that, so that the two are not the same. So I just wanted to insist that you be clear on what precisely the decision was.
Council.
Chair, so we would need the committee's decision on the fine to be given to both offenses. So currently,
there was a recommendation from the last meeting of the 500,000, or not last meeting, but from some meeting.
Right, I think it's 500,000 in the existing provision.
Yeah, the offense involving fraud and misrepresentation. Is that $1 million? I'd heard that earlier on.
right, but as Mr. Foreman is indicating, both the offense on the 25 and 26 are to be different. So if one is 1 mil and the other cannot be the same.
And we agree, we agree on the principle that the one that constitutes fraud and misrepresentation should be placed at the higher, and that in my mind would be the 1 million. And then now, we now have to deal with the offenses, the one that's pretending.
Right.
So
the one I'm pretending is 500. So
it's 500.
So if you increase, so if you increase the fraud to 1 million and leave the pretending at 500.
At 500.
The principle would be honored.
Right. So then we move to another one,
Chair,
Mr.
If just to understand what Mr. Foreman just indicated, so the offense under 24 and the 25 would be both $500,000. And the one for fraud and misrepresentation would be 1 million. Mr. Foreman, just need that
Right.
clarification.
Yeah, and well, the committee needs to tell us. But thank you for pointing that out, because the other point that the committee should consider. So 24 is a situation where the teacher has been given an opportunity to become regularized. The council tells them you need to get something from us to continue. You're given some time. Then the council tells you need to stop teaching, but you still continue to teach. That's the point at which the sanction comes in. After you're told to stop, after being given that time to regularize yourself, and you still fail to comply. Then the next offense is where you pretend to be a teacher. And then the next offense is where you're fraud, you engage in fraud to be a teacher. So the committee may want to consider whether each of these represents different degrees of wrongness and therefore attract different types of maximum sanction, or if you consider that the offense for continuing to teach after being told by the council to regularize yourself, and the offense for pretending are substantially similar, such that both offenses should attract a 500,000 fine, but the offense for fraud should attract the 1 million fine.
Which also has a custodial sentence.
Yes.
Yes,
So
Chair.
there'll be three different.
There are
offenses,
three different
yeah.
types of offenses. There's the first offense in 24, that you are not registered, you have been advised that you're not registered, and you must stop and go seek your registration. But you continue to practice as a teacher, and you would be found practicing, having been instructed to fix your business. That's the first one. The second one is that's a 500 that was established. The second one now is an offense of pretending. And as Mr. Foreman kind of worked it out. So this pretense, in my mind, can be also viewed as fraudulent. It is. Unless the fraudulent depicts that an individual would be practicing with fraudulent documents as evidence. And as counsels, that's where I'm having a little gray area, but I'm of the view that if you are pretending to be a registered licensed teacher and you are practicing, that too is fraudulent. and a misrepresentation.
Can I come in? Can I? I'm also of the same view because I'm wondering what is the difference. If you can clarify the difference between pretending and fraudulent, I think that is where the gray area is for me as well, because isn't that the same thing as fraud? I mean, fraudulent. Can someone explain the difference?
Chair, through you, my understanding.
Please go ahead, member. Or is there a question?
That would be unrelated, although somebody could be charged for both offenses, which happens from time to time, depending on how the crime is committed. But you can pretend to be a teacher without having any fraudulent documents in that regard, right? And you can have fraudulent documents that, in other words, you've gone out and you've gotten a fraudulent license, which in those circumstances, if you are pretending to be a teacher, you do have a fraudulent document, and you could be charged with both offenses. But I think the discussions that we had prior to was the fact that one would be worse than the other. So to simply roll into
Chair, the provisions on the both clauses, they indicate the different...
A difference in action.
Yes.
Yes, because 25 speaks to a claim. You claim to be.
Right.
And you take, assume, or use any name, title, or description. So you walk around and say you're a teacher.
Right.
Now, 26 is fraudulently make use of a license or authorization to teach. This is more evidence-based. Make or cause to be made any false declaration or representation for the purposes of obtaining a license. Looking at it, it depicts a higher level in action. So you'd have gone, you're not walking around and say you're a teacher, you'd have taken steps. Not only by going in a classroom, but by the purpose of obtaining a license or authorization to teach. So you may have, in fact, produced some documentation which are fraudulent in nature in an attempt to acquire the license or registration. You have stepped it up a notch.
I agree, member, and that should come with a higher fine. Go ahead, member Miller.
Mr. Foreman.
Madam Chair, I was going to say the same thing that you just said, that I believe that is stepping up a notch, and that should attach to it a higher fine, because you have deceived, you have misled, and you have made steps to fraudulently do things that are not in your remit.
So based on those discussions, the consideration that would need to be had, in my opinion, is whether we are going to, based on the happenings under 25, if we can attach a similar fine as 24, which is currently $500, not exceeding $500,000, and then the one for fraud, we give it the $1 million.
The 1 million, because the one that depicts fraud is elevated in nature.
But why not $1 million for clause 25 and $1.5 million for the fraud case? Because in the first in the first case, clause 24,
You're practicing without a license or an authorization to teach. You got the time to regularize and you did not. 25, you are claiming to be registered.
right. And in 26, you've just outright,
Right.
scammed us.
So 25, you're claiming to be registered, licensed, or authorized to teach, or you cause persons to believe that you are registered or authorized to teach or licensed.
This is the fake teacher.
So committee members, I would recommend for clause 25, $1 million, for clause 26, $1.5 million.
Let's hear from the other committee members. I was okay with 500, 1 million.
Member Miller?
I'm in agreement, Madam Chair. It's not that we want to collect the money, but it's a deterrent of people not doing what they're not supposed to do. And not only that, but basically, I'm sure chances are we don't have to, but we don't have to want to come back again to amend the act because the charges that are attached to it is minimal. So we want to ensure that the act has teeth and people, to prevent people from doing what they're not supposed to do. So I'm in agreement with the 1.5.
Right. So, what we're saying by this act is that registration or licensing is an important endeavor, one that we've codified in law to be respected. Yeah.
It don't matter to me the amount, just make the distinction.
Any other member wishes to put their agreement or disagreement on the table? All right, I am not hearing any other member. So, council? All in agreement, members? Yes, all right.
So we go back to no 30. Mr. Foreman, you had made an attempt to respond to 30. Your committee considered the recommendation to remove subclause 34, B and C, because the obligation it imposes is unlikely to be observed. These provisions place reporting obligations on persons who are dismissed from or resign from their employment to teach in response to allegations of unprofessional conduct or improper conduct.
Right. Yeah, Senator, I was going to intervene at the stage where you were trying to figure out if this was an obligation placed on the employer or on the employee. I was going to say that these provisions deal with the conditions placed on the registration of individuals. So it would be an obligation on the teacher to inform the counselor even if they've been dismissed or resigned because of some sort of fraudulent activity. And the discussion that took place in the deliberations was to the effect of, well, are these provisions practical, as the draft report states, because it was argued that a person in those circumstances is probably not going to make this report to the council because it's not in their interest to do so.
Right. That's what it meant, Chair.
Chair, just to indicate to the committee that under clause 26, it's a custodial sentence, and based on the previous fine, it's not exceeding 6 months, and so based on the increase in the fine, then we're proposing that the custodial sentence be increased to 12 months.
Committee members?
Because we would have increased the fine?
Yes.
Okay. All right. Make it more a deterrent. So we can now move to?
We are agreeing?
Yes.
We agree.
I just want Mr. Nash to get
Yes,
it
we
for his
agree.
record. Thank you.
So it went on to read under clause 3034 that persons is required to inform the council of that dismissal or resignation within 14 days. We also noted the recommendation that the administrators or the institution should be given this reporting obligation. So it's now saying that it's the institution should report. Your committee consider the entire subclause. We recommend that subclause 34A, which requires a person who is charged with or convicted of an offense specified as a condition of registration, a license or authorization to inform the council by written notice of that charge or conviction should remain, with consideration whether to limit the reporting obligation to circumstances where the person is convicted of a relevant offense. Your committee further recommends the deletion of subclause 34B and C, and do so while acknowledging that clause 62 of the bill imposes an obligation on employers to report dismissal or resignation of a licensed teacher or instructor in circumstances similar to subclause 34B and C. Right. Then we move to subclause 35. Your committee noted a recommendation to insert as the second sentence of subclause 35 the words, in quote, no delay or failure to report under subsection 4 shall bar the council from investigating any allegation of professional misconduct and taking such disciplinary action against the offender, end quote. Your committee accepts the recommendation with the exception that it should be indicated that the council can investigate and take such disciplinary and not placed in a list. That the council can investigate and take such disciplinary, should be a word after that, in terms of action, and not placed in a list.
Yes,
Chair,
and I had
in
a
terms of,
comment there. Oh, go ahead.
in terms of the reporting obligation of the employer, the report is saying under clause 62, but it's supposed to be read clause 63.
Okay. All right, so back to the statement, the last statement. Your committee accepts the recommendation with the exception that it should be indicated that the council can investigate and take such disciplinary action and not placed in a list. Subclause 35.
Yes, I think the word probably should be disciplinary action.
Disciplinary action.
Oh, yes, I think that's what was contemplated. But I had a comment there. I'd asked the committee to revisit this particular decision. And the bill has discrete parts. Part 7 and Part 8 in particular deal with investigations and disciplinary procedures. And in those circumstances, it's not clear to me what this proposed language would add to the bill. It's for the committee's consideration.
Mr. Foreman, if you don't mind, could you repeat your comments?
Oh, right. Yes, it's a comment that's in the document. Right. I noted that the provision seeks to insert the recommendation in the report. The purpose seems to be to indicate that the council can take action against a teacher even if the teacher does not comply with the reporting obligations in subclause 4 of clause 30. And the point I was raising is that the bill has discrete sections dealing with both investigations and disciplinary action. And those parts are pretty wide in nature and would allow the council or the school or anybody who comes to certain information to make a complaint against a teacher if information comes to their knowledge that that teacher was convicted of a particular type of offense and maybe the council isn't aware of it, or resigned because of a particular reason and the council isn't aware of it, etc. So there may already be sufficient provision in the bill dealing with the type of situation that the stakeholder recommended in this subclause.
And you pointed specifically to two parts, but could you point, Mr. Foreman, to the exact clause?
Sure. Yes, that's going to be difficult because the investigation and disciplinary sections were substantially reworked, as you are aware.
Right.
I don't have the proposed revision in front of me, but certainly in the original bill, clause 50, for example, complaints, provided that a person who alleges that a registered teacher, licensed teacher, or instructor has failed to comply with conditions imposed on their registration as a teacher and the license or authorization to teach, can make a complaint to the council setting out the details of that contravention. And that's as wide a complaint making power as one can find. And then arising from that complaint, the disciplinary machinery of the bill is invoked.
Council?
I agree with my colleagues' proposal and indication in relation to the insertion of that recommendation.
That we delete this one?
That the insertion of those words does not add to the bill based on the mechanisms under the bill itself.
Okay. So it's the words that are in quotation. No delay or failure to report, those
Yes.
words?
Yes.
Yes,
If the committee is not minded to include those words that were recommended, I can recommend a formula of words to reflect the decision, noting that the disciplinary provisions would take the investigation provisions in the bill would be sufficient for the purpose. I can assist Mr. Nash with that.
Okay.
All right. Anything further, Council? Okay.
All right, so we can now move to clause 31, application for review of condition. Your committee does not recommend any change to this clause. Under clause 32, review of condition by council, subclause 32.3, your committee noted the observation that subclause 32.3 did not reference an information notice being delivered to a person where the council refused to amend or cancel a condition imposed on their registration license and or authorization. Your committee recommends that the provision be amended to require the council to give an information notice in these circumstances. 33, cancellation of conditions. Your committee does not recommend any change to this clause. And then we move to the fit and proper criteria. Clause 34, fit and proper to teach, fourth schedule. Your committee does not recommend any change to this clause. And we move to part 6, registration, licensing, and authorization to teach, application for registration as a teacher. Criminal police record, check requirement. Over the course of multiple sittings, your committee deliberated on whether all teachers and instructors should be required to provide the written results of criminal record check. Part 6 continued. These deliberations focused on the responsibilities and duties teachers have for the children of Jamaica, a vulnerable group, the burden that would be placed on persons applying to the teachers and instructors to obtain a police record, and the significant improvements made in improving the process for applying for a police record and the speed with which the results are obtained. And there's a member here today that spoke of that. Your committee recommends that the bill be amended to require that all persons applying to the council to be registered, licensed, or given an authorization to teach provide the results of a criminal record check. Your committee noted the recommendation to give the regulations high priority as the detailed procedures and requirements for registration, licensing, and authorization to teach are normally dealt with in regulations. Your committee recommends that the development of the regulations be given high priority.
Yes, member. And I've heard since we made that change that it's even easier now to get a police record. Yeah.
Member Robert Miller was one who attested it apparently, because he spoke glowingly of it in terms of the improved procedures. That's a good thing. Yes. Chair.
Madam Chair, the services has improved significantly since then. And I'm a strong believer that once we're dealing with children, that is very important that persons that interact with them are fit and proper to do so. I'd even go as far as even those persons who operate transportation, public transportation, because I've known of issues where we have pedophiles and there are taxi operators and they're carrying our kids. And we have to be careful, and I'm in strong agreement with this recommendation. As last time we had the discussion, and it's much more easier now for persons to get their criminal report.
Thank you, member.
All right. So, clause 38, documents and other information in support of application. Your committee noted the concerns raised regarding the appropriateness of requiring the applicant to disclose the particulars of any spent convictions. Your committee recommends the deletion of the provision and its replacement with a requirement for the applicant to disclose to the council by way of a voluntary declaration the particulars of any prior convictions. By way of a voluntary declaration. Subclause 38, 5 and 6. Your committee recommends deleting subclause 38, 5 and 6, as clause 43 addresses the matters of which these subclauses are concerned. Clause 39, requirement to advise applicant of negative information from criminal record check. Your committee recommends the expansion of the clause to require the council to inform the applicant of any negative information about the applicant obtained by the council from any source. Your committee further recommends that the marginal note be amended to read consideration of negative information on applicant. Clause 40, council's power to obtain other document or information from applicant. Your committee does not recommend any change to this clause. Clause 41, effect of failure by applicant to comply with a request for other documents or information. Your committee does not recommend any changes to this clause. Clause 42, council may use documents or information to verify application. Your committee does not recommend any change to this clause. Member Miller, you want to rest my voice and use your baritone now?
Let me say thank you, Member Gale. You've been reading since the last meeting. Thank you so much.
Decision on application, clause 43. How council may decide application, subclause 43(2)(b)(1). Your committee recommends the amendment of subclause 43(2)(b)(1) to include a reference to the clause 38. Period of validity and renewal of license and authorization to teach. Clause 44, validity of license and authorization to teach. Your committee noted the recommendation to include a provision in the bill to prohibit the transferability and accessibility of license and authorization. Your committee agreed that license and authorization should not be transferable. However, it was not necessary to include a provision to that effect, as the license and authorizations were specific to individuals. Application for renewal of license and authorization to teach, clause 45. application of renewal and license or authorization to teach, clause 45(4)(a) and B, your committee considered the recommendation to delete subclauses 45(4)(a) and B, as well as related provision in clause 46(1)(b)(2), because the requirements of currency in practice in order to renew a license or authorization might make it difficult for persons to re-enter the profession after a period of inactivity resulting from various reasons such as illness. Your committee does not accept the recommendation to delete the provisions, but recommends that the number of consecutive years of practice referred to in clause 45(4)(a) be reduced from 3 years to 2 years. Clause 46, manner in which council may decide application for renewal of license or authorization to teach. Subclause 46(5). Your committee noted the recommendation for the employer to also be notified if the council decides not to renew a license or an authorization. Your committee recommends that the provision be amended to include the notification of the employer and the teacher or instructor. Documents evidencing registration, licensing, and authorization to teach. Clause 47, form of license and authorization to teach. Your committee does not recommend any changes to this clause. Clause 48, amending or replacing license or authorization to teach. Your committee does not recommend any change to this clause. Deregistration or revocation of registration, license, or authorization to teach. Clause 49, deregistration, revocation of registration, license, or authorization to teach. Clause 49(3). Your committee noted the concern that there is a lack of consistency in time frames between subclause 49(3) and 61(4), as both provisions related to the same topic, but the former required return of the license or authorization within 14 days, while the latter specified 7 days. Your committee agrees with the concern raised and recommends that the subclause be amended to prescribe 7 days. Complaints. Comments. JF 14. The committee later decided to delete clause 61(4). The committee should consider whether 49(3) should also be deleted. Committee have to decide? Okay. Complaints. Clause 50.
Sorry, hello, Chair. Right, so this was a comment that I had made. I'm sure at the time I made it, it made complete sense to me. Don't quite remember what the point was there. So might I ask that we maybe return to this one at a later point?
The footnote. Right here? Right here. This is where I read from.
Just to inform those online, I don't know, well, you should be seeing, or legal counsel is talking. They're discussing. Legal counsel, is there anything?
Chair, I know Mr. Foreman said that he wanted time to refresh his memory as to why he had proposed the deletion, or sorry, not proposed the deletion, but to bring the committee's attention to the fact that they had deleted a similar provision under section clause 61(4), and that provision under 61(4) also had a penalty provision to it where the person fails to surrender his or her license. I'm not sure if Mr. Foreman is remembering now, but if not, then I would agree to allow him time to refresh his memory as to why.
Mr. Foreman?
Right, no, I don't. I mean, I noticed 61 is under the disciplinary provision, so maybe after we've gone through that, my memory will come back to me. But it may have come from a notation that a decision was taken in relation to that provision in clause 60 in 61. But I'm not sure exactly why that note was made. It made sense at the time. It may make sense again in the future.
Yes, made sense at the
At the time, there was a statement made by someone that there is a public service regulation that concerns a similar matter, and it should be used instead of what was written here. And that was coming from, I suspect, the AG's office. There's a regulation somewhere that we should look at and substitute what is there, and it's a public service regulation.
Mr. Foreman?
Thank you, Chair. My mind is still foggy. So I repeat my earlier request to come back to this one. Right. It might be a very small matter.
Yeah, we'll give you some time.
So it should be easy to resolve later on.
Yeah, all right. We'll give you some time. Carry on, member.
Thank you, Madam Chair. Part 7, complaints, clause 50, making a complaint against a registered teacher, licensed teacher, or instructor. Clause 50. Your committee recommends the inclusion of a subclause, which enables a person to make a complaint that a registered teacher, a licensed teacher, or an instructor has been charged with or convicted of an offense in Jamaica or any other jurisdiction. Your committee considered that it should be sufficient for complaints to be made in writing and therefore recommends a deletion of the requirement that complaints be made in the prescribed manner. Open and close quotation. Part 7. Investigation, disciplinary inquiry, and action powers of investigation. Your committee received various submissions on Part 7 of the bill and considered that deliberated on those, Part 8, sorry, on Part 8 of the bill and considered and deliberated on those and other issues over several meetings. The matters deliberated on concerned ensuring that there were different avenues to consider complaints made against teachers and instructors, the position of the Board of Public Educational Institution and employers in relation to disciplinary action being preserved, and ensuring that there are fair and efficient procedures for conducting disciplinary inquiries. Part 8, investigation, disciplinary inquiry, and action powers of investigation continued. A major part of the deliberation was whether the Professional Practice and Conduct Committee, PBCJ, after considering a disciplinary inquiry, should make a recommendation to the Council for the Council to decide whether to accept that recommendation, or alternatively, whether the PBCJ should make the decision, which decisions may be appealed to the appeal tribunal. Your committee decided that the latter position should prevail, having regard to the composition of the PBCJ. The fact that it would be the entity to hear all the evidence and therefore be best positioned to make the decision of the facts before it. The expected workload of the Council and the impact that would have on rendering a final decision in a reasonable time, and the ability of a dissatisfied party to appeal any decision to the appeal tribunal, therefore providing a means of correcting any errors made by the PBCJ. The redraft provision reflecting the recommendations of the committee are included in Appendix 2 to this report. Our committee sets out below a summary of its main recommendations. Upon receipt of a complaint, the Council should refer the matter to either the professional practice. The Council shall refer the matter to either the Professional Practice and Conduct Committee, PBCJ, the board of the relevant public educational institution, or to any other employer of the licensed teacher or instructor. Where the matter is referred to the PBCJ should either refer the complaint to an independent investigator for investigation or proceed to conduct a disciplinary inquiry. Where the matter is referred to the board or other employer, the board or other employer should take disciplinary action. And if the complaint is not heard and decision handed down within 6 months of the referral, the Council shall refer the matter to the PBCJ for inquiry. If a complaint is made directly to the board or other employer for disciplinary action, the board or other employer must notify the Council of the complaint. If the complaint is not heard and decision handed down within 6 months of the referral, the Council shall refer the matter to the PBCJ for inquiry, but can also grant the board and other employer additional time to hand down the decision if there is just reason for doing so. The board and other employer must take no further action in the relation of the complaint if the Council makes the reference to the PBCJ.
I want to go back to just a clarity in terms of the sequence of events. So it says, upon receipt of a complaint, the Council shall refer the matter to either the Professional Practice and Conduct Committee, the board of the relevant public education institutions, or any other employer of the licensed teacher or instructor. Where it is referred to the PBCJ should either refer the complaint to an independent investigator for investigation or proceed to conduct a disciplinary inquiry. So that establish conducting an investigation or the pursuance of an inquiry. Where the matter is referred to the board or other employer, the board or other employer should take disciplinary action. Now, this is the reference of a complaint. And in the sequence of events, the reference of a complaint should go through certain procedural steps. I'm just looking at this and trying to jog my memory in terms of what is stated here. In terms of the reference to the board, it moves, the impression it gives here is that it moves strict to disciplinary action based on what is stated here. I just want to be sure that whatever is contained in the bill itself is not proposing what is said here. Because this would not be procedurally fair to jump to disciplinary action.
Also,
No, the disciplinary action is contemplating in furtherance of certain procedures, investigation, hearing, and then you take the action. All right.
But there's all, I'm asking,
I just don't like how it sounds in terms of it jumping here. What is the disciplinary action? Because the disciplinary action is the
Council,
result.
could you go on microphone, please?
Is the result of going through the level of procedures. The action, is what you're going to do to the individual having gone through the procedures of a hearing or an inquiry. That results in the contemplation of an action. So this speaks to the employer should take disciplinary action and not to commence proceedings.
So remember
Chair?
you're saying instead of, go ahead, Mr. Foreman.
Right. I take the point made by Senator Gale. My initial understanding, and I can appreciate his question, but my initial understanding of the redrafted provision was that it contemplated the disciplinary process in the education regulations, which would involve personnel committee meetings, board receiving report from personnel committee,
Right.
board taking a decision.
That's the process. That's the process.
Right. So, I suppose if the committee accepts the point and subject to the thoughts of the drafter, the redrafted clause may be amended somehow to make that clear. But just to read what I think I'm looking at as the most recent version of the redrafted provisions, it says, upon the receipt of a complaint under Section 50, the council shall, based on the circumstances and particulars of the complaint, A, don't need to read that, B, refer the complaint to the board of the relevant public educational institution for disciplinary action pursuant to the education regulations. So the redrafted provision itself does make a reference to the education regulations. But I suppose if the committee is more comfortable with language that would say disciplinary process rather than action, or perhaps a specific reference to that section of the regulations that begins with the start of the process. Again, subject to the thinking of the draft and the form of words. And change might help to clarify that point. Because my assumption as well is that the wording was intended to mean the disciplinary process under the existing education regulations.
Under the regulation, it says, it defines it as disciplinary action. Yes. You can just read it out for me.
It says, under regulation 56, it says, where the board of a public educational institution receives a complaint in writing that the conduct of a teacher employed by the board is of such that disciplinary action ought to be taken against the teacher, it shall, as soon as possible, refer the matter to its personnel committee for consideration pursuant to Regulation 85.
And that's defining disciplinary action.
So the disciplinary action that would flow would be that the personnel committee is to consider the complaint, and if it is trivial, then they will report that finding to the board that a hearing is not necessary, and if it finds that a hearing is warranted, then they go through notifying the accused person of the hearing that is to be scheduled.
I'm going to come back to that in my mind mentally. I just have a concern in terms of what is depicted as a disciplinary action as to what is defined there as a procedure. I will come back to it. Go on, sorry.
And just a question from me in this document we're reading. It would seem that for the last sentence, or the part of it that starts with, and if the complaint is not heard and decision handed down within 6 months, and the decision is not handed down, right? Maybe it's just worth repeating the is not, because I had to read it several times in order to... I know, but you have to read it like 3 times to really get it. Out of an abundance of clarity. All right. So are we waiting for Member Gale?
No.
Okay. We're waiting on anybody else? Okay, go ahead, Member Miller.
The board or other employer should be able to request from the PBCC conduct an inquiry into a complaint that was referred directly to the board or other employer. When an independent investigator is appointed to investigate a complaint, the investigator's report must be submitted to the council, and the council must submit the report to the PBCC for the PBCC to determine whether to proceed with an inquiry or not. Continue. If the PBCC decides to proceed with an inquiry, it must ensure that the procedures detailed in the bill for the conduct of inquiries are complied with. To the end, your committee recommends for inclusion additional measures to be observed in the conduct of inquiries. A provision should be included to expressly acknowledge that a party to an inquiry may be represented by a body which represents the majority of teachers in Jamaica. The PBCC should have a duty to submit a report to the council setting out the decision that was made, the reasons for the decision, the date the decision takes effect, and for how long. The council, after receiving the report, must provide a copy of the report to the person who is the subject of the complaint and that person's employer. If after completing a disciplinary inquiry in relation to a teacher or instructor, the board or other employer of that teacher or instructor recommends suspension or revocation of a license or authorization to teach, that recommendation should be made to the council within 7 days. The council must then refer the recommendation to the PBCC for the PBCC to make a determination of the recommendation. The decision of the PBCC should be communicated to the council, and the council must then notify the board or employer as well as a teacher or instructor who is the subject of the complaint. Where an employer is notified that a teacher or instructor license or authorization has been revoked must take all steps to ensure that the teacher or instructor ceases to teach for this specified period. In circumstances where a teacher or instructor whose license or authorization was suspended because they were charged with a disqualifying offense and that charge is dismissed or the person acquitted, they are to be entitled to the full amount of the salary which they would have received if that person had not been suspended. Repayment of salary should only apply where a person's conviction for disqualifying offense is overturned or squashed and on appeal.
Chair, I recall an extensive discussion in relation to the repayment of salary upon appeal and the issue that it would have on an employer who is not a public educational institution. And I remember Member Braham also speaking about that and saying that employer might have an issue paying those monies, especially based on the system where appeals take a long time to be heard. And so I am almost sure the decision was taken to not include a provision in relation to repayment of salary in that regard. If it's so, especially if it's, for example, one of those homeschooling where it's a private employer, that person would have to employ someone else in that person's space until the matter is heard. And so if it happens that the appeal is quashed or overturned, then it would mean that that employer would have to pay that person all of those monies up to the time that it's quashed, and also would have had to pay the replacement person. So I'm sure there was an issue where that is concerned. I'm not sure if the committee members recall.
I recall the discussion. Member Braham is not here to defend what he had recommended. I don't think the committee had concluded on this matter in terms of an agreement, because I recall parts of the discussion was whether, okay, on the one hand, you're going to place the burden in the public, on the public space. But on the other hand, the burden is not being placed in the private institutions. I recall also discussions around whilst they were on suspension or administrative leave, or they were, out, they would have been also earning part payment. You weren't paid in full, but you were paid part of your salary. I remember discussions around that. But I don't think the committee had concluded on those matters, especially in light of what Member Braham had raised in the last part. In the public sector, if you are interdicted, you would get a part payment whilst the procedures go through. No, not necessarily. Not necessarily the appeals procedure.
But isn't that what we're talking about here? It's the appeal procedure we're talking about here.
This one is specifically speaking whilst you go through the appeal.
Yes.
But I don't believe that we had agreed on how, if payments were to be made. And it's really something that the committee really has to deliberate on. Because it was never intended in the first place.
Okay, we're gonna defer this.
You see, where I know there has not been an agreement on this, and since the mere fact that Member Braham would have raised it, I would not have wanted as an individual member to advance a discussion without having further deliberations on this one. But I can understand the extent to which you would be placing burden on any employer, whether private or public, in treating with this, because it can be the entire school funds for a small institution.
All right, we'll defer the consideration for this one. Carry on, member.
There's a comment. The
Yes,
redraft.
that comment is connected to the underlying policy decision. So it would be coupled with whatever decision is taken when that matter is discussed again.
Okay, sir, Foreman. Where a teacher or instructor had their license or authorization revoked, the law should provide for circumstances where that person can be reinstated. However, where the person was convicted of a disqualifying offense, the person cannot be reinstated. The council should have the duty to instruct the registrar to take all actions necessary to give effect to the decisions of the PBCJ. Part 9, Appeals. Clause 65, Establishment of Appeal Tribunal, 5th Schedule. Your committee does not recommend any change to this clause. Clause 66, Appeals to Tribunal. Your committee does not recommend any change to this clause. Footnote, the committee is invited to consider recommending an amendment to this provision to include a reference to decisions taken by the PBCJ to make clear and such decisions could be appealed to the appeal tribunal. Sir Foreman?
Yes, that recommendation, that comment was made by, that comment, I think would be a small change if nobody is violently opposed to it. So I should add, so the provision right now says a person who is aggrieved by a decision of the council or a disciplinary action taken by the board of an educational institution or any other employer of a licensed teacher or an instructor may appeal to the tribunal against the decision within 28 days of being notified of the decision of the council or the other employer of the licensed teacher or instructor, as the case may be. And this provision reflects the fact that the original bill referred to the council as the entity that conducted the disciplinary hearing. So my recommendation is that in light of the fact that the decision has been made that the PPCC will be the entity specifically charged with doing disciplinary actions, conducting disciplinary procedures under the bill. As for good order, it would be useful to include that entity in the list of entities referenced against whose decision an aggrieved person can approach the tribunal in respect of.
Clause 67. Procedures to apply in relation to hearing of tribunal.
Sorry, sorry to interrupt. Just to be clear for when the next version of the report is completed, is the committee accepting my recommendation? Because the language the next iteration of the report would need to be adjusted if that's the case. If you're not accepting the recommendation, then there's no need for a change in the report.
All right, we can deliberate, but we'll have to ratify it at the next meeting.
I think we can get guidance from the legal counsel, Madam Chair.
Mr. Foreman, can you repeat the recommendation in terms of the PPCC? Are you proposing for its replacement with the council or to add?
No, an addition, because
Okay, because
I
the
mean, I assume that there may be decisions of the council
Right.
that are not disciplinary in
Right.
nature that you want the appeal tribunal to
For
be able to hear.
example,
For
not
example, if
granting the
not
license.
granting a
Yeah.
license or authorization, precisely.
Right.
But in light of the fact that the PPCC is now going to be
Make the decision.
right, the entity that deals with the disciplinary process, I'd say it's probably more convenient to include them, expressly include them in these provisions.
For clarity.
I mean,
yeah.
without it, it's sort of implied that you can appeal to the tribunal, but
Adjusted.
without doing things expressly, if we're clear on what the policy intends.
So to ensure there's no ambiguity.
Right.
I agree. I agree.
Carry on, member.
Subclause 6.
Based on what council had asked of Mr. Foreman and given Mr. Foreman's clarity, then we can agree. I'm suggesting that we can.
We'll ratify at the next meeting. We'll ratify at the next meeting.
Subclause 67, 1A. Your committee noted a typographical error that the numeral 1 was inserted as a subclause before paragraphs A-D without there being a subclause 2. Your committee recommends correcting the error with the deletion of subsection 1 and replacing the word complaint with the word appeal. Carry on.
Chair, just for clarity, because as it is now, it kind of read as one correction, or if we want to specifically indicate, to say and also, replacing the word complaint with the word appeal. Just a suggestion. Just to insert also after and
Right.
between and replacing.
And replacing. Thank you. Member Miller.
Subclause 67, 1D. Your committee recommends the deletion of clause 67, 1D, which provides for the tribunal to hear matters ex parte. Your committee accepted that the rules of natural justice will apply. Clause 67, evidence before tribunal. Your committee does not recommend 68, clause 68. Evidence before tribunal. Your committee does not recommend any change to this clause. Clause 69, attendance at hearing. Your committee does not recommend any changes to this clause. Subclause 6914, your committee recommends the insertion of the word in between the words give and evidence in the second place where the words appear. The amendment would read, a person served with a notice under subsection 1 shall not be compelled to give evidence or produce any document which the person would not be compelled to give in evidence or produce in any proceedings before the court. We have some comments to the side. The words give evidence appears twice in clause 694. The recommendation appears to be referring to the second place. The word appears in the clause 694. However, the recommendation is not grammatically accurate. The drafter needs to provide the wording to address the concern, and the recommendation would need to be amended accordingly.
Members, as you contemplate, I'm asking that we stop at clause 70, only because there's another meeting bearing down on me. I know we'd love to continue. No? Clause 70?
You could go to 71.
71? Okay.
Right. That's the 71. Clause 71 is the last clause in part 9, and then the next meeting you could start at part 10.
All right.
Chair, the drafter is suggesting that the word evidence be removed from the second part of 69(1)(4). Mr. Foreman, do you think that would be a good fix? So it would read, would not be compelled to give or produce in any proceedings before a court. So it said a person served with a notice under subsection 1 shall not be compelled to give evidence or produce any document which the person would not be compelled to give or produce in any proceedings before a court.
Yeah, that sounds better. Yes.
Okay. Thank you.
Clause 70, right to representation. Your committee does not recommend any change to this clause. Clause 71, decision of tribunal. Your committee recommends that the initial period within which the tribunal should give its decision be increased from 28 days to 42 days. Subclause 71, 1A-C. Your committee recommends that the subclause should remain unchanged.
right, let me thank members Gail and Big Rob.
That's all right. Just for the record, Madam Chair, which was brought to the attention. Yes. I want to ensure that my name is written there.
Noted for the record, absolutely.
Thank you, Madam Chair.
Transformational.
Absolutely.
All right, so let me thank everyone for being here. The next meeting would be, we have 2 meeting dates. Thursday, May 30, 2024 at 2 p.m. and Thursday, June 13, 2024 at 2 p.m. All right, Thursday, May 30th, 2024 at 2 p.m. and Thursday, June 13th, 2024 at 2 p.m. Okay. Two p.m. Yeah, both are 2 p.m. in the afternoon, then at 10 a.m. Yeah. All right. Thank you again, members. The hybrid meeting of the Joint Select Committee on the Jamaica Teaching Council Act 2022 is hereby adjourned.